Filing a fresh application under Rule 154 of NCLT rectification application must be decided on merits, considering legal effects under Section 420 of Companies Act 2013.
Filing a fresh application under Rule 154 of the NCLT rules for seeking a rectification of the order, which has to be decided exclusively on its merit, taking into consideration the legal consequences flowing from Section 420 of the Companies Act as dealt with. Do you agree if we send you back to this?
The reason, the contradiction is, he says after you file an appeal, 420 bars.
The
last para contradiction, he says go back.
You are right. You are right.
Because I am saying, this, your only ground is made is that EBPL had no administrator. After he finishes, I will show the pages. They wanted a buyout.
This 420 thing we can take care of. That 420 will not be made applicable.
I will agree not to press 420 at all. I will agree myself.
The jurisdiction was
We have just
whole
put
thing will be re-argued. But last the administrator, that's his whole object. He wants fellows by a remand of any kind.
Okay.
The whole matter is argued.
Okay.
Companies are protected. There is no administrator.
Okay.
Matter is hanging. And I will show why the administrator appointed EBPL also.
Of the judgment of the NCLT, which is the subject matter which has been appealed, the final judgment. Unless it is volume 2 of with the appeal, with the civil appeal, volume 2.
just a minute. Just a minute. Just a minute. What are you reading exactly, Mr.
I'm reading the judgment which has been rectified. Judgment which has been rectified.
Just start. Just let us see what is the sentence.
Analysis and finding.
It is pertinent.
Analysis and finding.
Yes. Analysis and finding starts at page 598.
Now we got it. Now we got it.
We wish to state that the expression oppression and mismanagement is not defined. Therefore, task of defining constitutes oppression and mismanagement is the task of the courts, etc. Now, next paragraph. It is pertinent to observe herein that in our discussion under points 2 and 3 above, we have categorically held that the acts and actions of the members of Deccan Group towards EASPL and its directors, that is me, against EASPL and its directors mentioned, constitute acts of oppression. Therefore, when multiple acts of oppression is established, the tribunal may, with a view to bring an end to the matters complained of, make such order as it thinks fit.
This is 45.
Both combined judgment. Because it's fine when if you go through the whole order, there is no finding against EBPL because EBPL did not have such articles. EBPL's articles are as per the Companies Act.
Okay.
Majority of the directors and majorities.
Okay.
No question.
Okay.
Now, my lords, kindly see point 5. Whether the appointment of CEO is contrary to the Articles of Association of EASPL. Insofar as appointment, again, because this was the other act of oppression, they said was appointing the CEO without their consent. That was only EASPL because the article of EASPL required the consent. Now, please come to page 609. 609, the final. Let me start. No, PDF. His Lordship is asking for PDF. Manjot, is there a foot page 531?
Therefore, in the light of our findings on point 2,
whereby so and so has been appointed as COO cannot be held. That is EASPL. Nothing to do with EBPL. Then your lordships will see point 6. Whether Pendles have caused loss of 13 crores. Then your lordships will see, according to counsel, Deccan Group with clear malified intent have alleged injury. Pendles have caused INR loss of so and so to EASPL on the sale of spent solvents. Counsel says, etc. So here also it is EASPL. Having said all this only about EASPL, it comes to the oppressor. Where is EBPL and oppressor? Then your lordship will see, therefore the finding against me is to sell. That's all. That's the order against me. Now please see 657. 657. Why is EBPL also said? 657, if an order by the EASPL is made in favor of the petitioners by giving them first right to buy the shares, EBPL should also sell. I am very angry with this finding. Now, my lords, that is why I am filing an appeal. Now, please come to the actual judgment. At the end of all this, the actual order is at page 662. Yes, I'm coming to it. Page 662.
Yes.
Last paragraph of 661. In the above CA, it is contended email sent by address to EASPL transpires that despite the gravity and seriousness, the applicant and respondent 7-8 have disclaimed responsibility, etc. Then it goes on to see at page 663, second paragraph, application is resisted strongly by the applicant and respondent contending, 662, foot on the page. It is also contended that the need of the hour is appointment of an independent, qualified and experienced professional having high integrity and industry knowledge as an administrator to take control of the manufacturing premises of EASPL, which will also ensure a free and fair investigation. Application is resisted strongly, etc. And the final order is thereafter passed at 667 on this application. At 667, therefore, this tribunal appoints. This is the final order. So and so, as the administrator of EASPL, and to save all doubt, the whole name of EASPL is not a question of this thing. For an initial period of 6 months, commencing from the date of appointment, administrator is directed to file acceptance. Upon appointment of administrator, powers of the present board of EASPL shall stand suspended, and the administrator shall take control of all the affairs. Directors of EASPL shall provide all the required support for the EASPL.
Now, administrator, so far as EASPL is concerned, is continuing.
Now, please see, everything goes on to 8 regarding what they're saying basically is, you sell the shares. Till the shares are valued and sold, let an administrator be appointed for that company, because that's the manufacturing company. Now, as far as I'm concerned,
Now, where is the operative part of the order?
this is the operative part.
No, where Dr. Singhvi laid stress on 44 allowed.
I'm coming to that. Now, my lords, kindly see, page 675. I'm agreed from here. The administrator is only appointed for EASPL. But in my case, 675, we hereby appoint Mr. So-and-so's details are under as the valuer for valuing the shares of the company petitioners in EASPL and the second respondent, namely Deccan Advance, as per the standard valuation process. And over the page, in the result, CP 45 is allowed to the
Where are you reading?
677. My note said there is 644. Result CP 45 is hereby allowed to the extent indicated in the order, however, without cost. CP 45 is also hereby allowed to the extent indicated in the order. 44, that is EBPL. So, what is to the extent stated in the order that I must sell my shares? Not that there is an administrator appointed.
And according to them, what is the error crept in?
The administrator should have been appointed for EBPL also.
Achha.
Since it's been allowed also for EBPL, administrator should have been appointed for EBPL also. Now, why am I agreeing, Manoj? I say...
No, just a minute. When they said that administrator should also be appointed for 44, NCLT in fact appointed an administrator in a rectification. Huh?
In 45 to the rectification, not in 44. Let me answer my lord.
But 45 to otherwise also was allowed.
So then what happened was, after the 11th, so what they say is, since 10th we had said it was for EBPL also, and in 45, so on 24th, they say the administrator files for substantial disparity relief. They say we not give you the relief because we carried out the corrections ourselves. And what is the correction? 45 changed to 44. 45.
But in 44 also they did pray for appointment of an administrator.
Yes. Management.
Okay.
The main substantive appeal is that the
Fine.
finding of oppression is wrong.
Okay.
My lord, I want to put an end to this. I have now got a suggestion. My lord, question of my selling out, I am the majority.
You want to put an end to the arguments?
Put an end to this case.
We can close it here and now.
Once and all for the case, I'm saying.
Acha.
I have a suggestion. My lord, the finding is you can't live together. Very good. I'm agreed because I've been asked to sell out as a majority. Since when can the 76 majority be asked to be sold? Minority, I'm agreed. However, I'm valuing this company, I have valued at 1,200 crores. Both the companies. I'm willing to give them option to purchase. My shares are press, failing which I will purchase their shares. After all, value has to be appointed. And they have to.
Well, that's
No,
between you all.
Consider this. What I'm saying is,
Fine.
total seminar buyout.
Well, y'all want to, it's all right. Y'all want to say anything in rejoinder?
Just one additional,
Hi, yes.
just one additional fact. After the administrator comes into charge, he files a memo, my lord, on 21st March 2025.
Yes, except 1 second. And then, Lordship may kindly come to page 24.
Yes.
The operations and business on the first, the operations and business of EASPL R1, EBPL, respondent number 1 CP44, and ELS are interlinked with the Deccan Group holding a 75% shareholding. And my lord, in the case of ELS, the Deccan Group holds 75%.
You are not answering our question.
My lord, the answer. The administrator has been given consequential to buyout. Lordship may kindly see.
Where is the appointment for both the?
My lordship, on 10th March, my lord, and immediately after this order was uploaded on 10th March, which is now in page number 12. Lordship,
Dismiss. Next matter.
Lordship, may kindly see page 12, my lord.
19, para 19 of the impugned order reads thus. Having heard the learned counsel appearing for the parties for quite some time, we are of the view that para 19 should protect the interest of both the sides. Next matter.